On Friday, the former Paralympian Oscar Pistorius was denied bail by a parole board. The Department of Correctional Services said that he had not completed the minimum detention period required to be considered for parole. Legal expert Kelly Phelps joins us now to explain what's quite complicated maths and working out exactly when an inmate is eligible to apply for parole. Kelly, good afternoon to you and thank you for your time. How does the maths work? Where do the calculations actually start?
Hi there, Stephen. Thanks for having me. Well, the calculations start at the point at which the sentence is effective. So in other words, when the sentence was construed to begin. And the maths that would be required is not actually complicated. It's simply in a determinate sentence like the one that Mr. Pistorius got, which is for a determined period of time, 15 years minus a year and 7 months. It would be at the halfway point of his sentence. So the only thing that is required in order to determine when he is eligible for parole is firstly to determine when his sentence started officially, and then you can work out what the halfway point is. And it's actually in the former point, when it started, that the confusion has crept in.
So this also goes to the time he served before he was actually convicted and his sentence began. Is that right?
That's correct, except if one looks at the sentencing judgment from the Supreme Court of Appeal that they issued in November 2017, they explicitly make reference to the time served for culpable homicide. So we know that they took the time he served for culpable homicide into account in discounting what would have otherwise been a 15-year sentence. So that was taken into account in determining how many years he was given as an effective sentence. So it started at 15, they minused a year and 7 months, and from that point, his sentence now needs to continue. The effective date should have been July 2016, which was the point at which he was first sentenced for murder. But the confusion now appears to be that the Supreme Court seems to be stating that their sentence should actually be read as effective from November 2017. But that simply can't be right, because if that's the case, then they are ignoring the year and 5 months that he had spent in jail on the murder conviction from July 2016 to November 2017, because the culpable homicide conviction was already taken into account in determining the quantum of punishment.
I realize that the court didn't have access to ChatGPT when it made this decision at the very beginning, but surely they should have been able to get the maths right without it?
Well, absolutely. I mean, it's deeply worrying that they haven't. And in fact, they've made two mistakes. They've made a recent mistake where they've said that the sentence was effective from 2017 rather than 2016, which is really a very simple matter. It's very simple to construe the right date, even on their own determination. And it's inexplicable why they would have made such a simple error. But if one goes back to the sentencing judgment itself that they originally issued in 2017, they appear to have made errors there too, because they have deducted his sentence by this term of a year and 7 months that they say was what he served for culpable homicide, a combination of prison and correctional supervision. But in fact, that length of time does not equate with the time that he did serve for culpable homicide. That would suggest that when they issued the judgment, they didn't closely actually study the record and go back to the history of the case to check their dates, which is deeply worrying indeed. I mean, that is the primary job of what the sentencing court needs to do. They need to be taking heed of the record before them. And I can't believe that that happened, and they still managed to make a mistake with the figures involved.
So if a Supreme Court of Appeal gets the maths wrong and the date wrong, and that means that someone has to stay in jail longer than they should have, what happens then? Can you go back to those judges and take out your red pen and explain to them where they got it wrong, or do you have to go to the Constitutional Court?
No, he shouldn't have to go to the Constitutional Court. There's two avenues open that I believe from reading newspaper reports today his legal team are considering. The first is to make an application to the Supreme Court itself and request that they clarify their judgment and they clarify the sentence. That would be an expedited process under something called Uniform Rules 42 of the courts. And the reason there is this opportunity to do an expedited process is in the interest of justice, so that an accused or a convicted person doesn't have to now feel the expense of, protracted legal representation and lengthy delays in order to clarify a matter that should easily be capable of being clarified. That deals with the mistake that the Supreme Court of Appeal have issued both in terms of their sentence and in terms of their guidance as to when the sentence should be read as effective. The second thing that it appears they're going to do is challenge the decision of the Correctional Services Board to actually not consider his parole on the grounds of this mistake. That, unfortunately, is an application that has to go to the High Court. So that would be a lengthier and more expensive process. So the outcome of the matter will be determined by the combination of both of those two things that they're doing.
Oscar Pistorius, as we know, had one of the best lawyers in the country representing him during his trial. There's been huge public attention, was taken live on CNN, etc. There must be so many people where courts, if they've made a mistake here, high-profile case, have made mistakes, and yet these people didn't have lawyers who picked it up, didn't pick it up themselves, weren't actually able to challenge a decision. I mean, could it be that there are actually quite a few people in South Africa who've been in jail longer than they should have been?
Absolutely. I would think that it's a certainty, in fact. The criminal justice system is under strain at the moment. That will compound the problem. You add to that it has always been the case that the vast majority of people who become subjects of the criminal justice system, in fact, are the most indigent people in society and don't have access to very well-heeled legal representation. They form just a number in the queue at the legal aid office, and the legal aid lawyers, as good as they are terribly overburdened. And so we know that there are massive problems with justice in this country for the vast majority of accused persons. And in fact, that's why I would hope that despite the fact that Mr. Pistorius appears to be a very unpopular convicted person with the public, and that the public are very angry about his case and seem to be celebrating the fact that his parole has been denied, this is not something we should celebrate. It's something that we should all be deeply concerned about, because we are all impacted when a criminal justice system is not functioning properly. And if, as you say, if it's happening in a high-profile, well-represented case like this one, it really doesn't bear thinking the sorts of errors that are happening in the vast majority of cases going through our courts all the time at the moment.
Now, all of this is about the timeline to apply, a timeline at which you become eligible to apply for parole, if I've understood the wording correctly. Just because a certain amount of time has passed at this stage doesn't mean he gets it, right? He would have to serve the full 15 years for it to be automatic. He can apply for a parole, but that's all it says.
So absolutely. And to be clear, if he served the full 15 years, then he wouldn't need parole at all, because at that point his sentence would have expired, right? So parole only becomes relevant when a sentence hasn't been concluded. And it is a mechanism by which we can continue punishing someone. They can continue serving their sentence, but rather than serving it inside of prison, they serve it in the community. And that's why parole comes with stringent conditions attached to it, because it is still punishment, in fact. The person is still completing their sentence, and the parole would last until the end of the 15-year period, or in this case, the effective 13-year period. So it's absolutely not a right to be granted it. It is, in fact, a privilege that one has to earn, but there is a right to be considered for it, and there also is a right that the decision is made on rational grounds. So all administrative decisions need to be taken on rational grounds. So if someone is denied parole on the basis of an irrational ground, they can successfully, and it has happened before, challenge that in court and then get it granted. But the right isn't to the parole itself. The right is to be considered, and for that consideration to happen on a rational basis.
Kelly Phelps, thank you so much, legal expert. Really do appreciate the time. Oscar Pistorius' story, of course, not over yet.